Please proceed.
Good morning, and let it please the Court. My name is Sarah Willey. I'm here on behalf of Appellant MidMichigan Medical Center Gratiot. I'm here with my colleague Patrick Giacomo today. The issue before this Court today is whether an individual's communication, phone call with her private attorney is a report to a public body within the meaning of the Whistleblower Protection Act. We believe that this is a significant issue, and it's certainly an issue of first impression for this Court. We ask this Court today to reverse the Court of Appeals ruling. The Court of Appeals held that the Michigan State Bar falls under the fourth type of public body in the Whistleblower Protection Act, the other public body, and also held that because a private attorney pays dues to the State Bar and holds a bar card, that means that that private attorney is then a member of a public body such that the attorney himself is a public body for the purposes of the Whistleblower Protection Act. And I'm sure today we're going to get down into the weeds and talk about the meaning of specific words in the Act. But at the outset, I would like to say that the primary goal here when we review a statute is to give effect to the legislature's intent. And so if we talk about the forest instead of the trees for a minute, I think we can all agree that the intent of the Whistleblower Protection Act is to prohibit employers from taking adverse action against individuals because they blow the whistle, because they report something to somebody or somebody that has authority to redress a legal violation of some sort. And here, the effect of the Court of Appeals ruling cuts to the heart of that, because a private attorney actually has no authority to directly redress any legal violation at all. And so the Court of Appeals ruling really eviscerates the purpose of the Whistleblower Protection Act itself.
So I have a question, though, and I appreciate your argument, but isn't that really a legislative issue? I mean, is that something that you should, I mean, it's a passionate and very well-thought argument, but I guess my question is, isn't that more of an argument that you should be making to the legislature and not necessarily to us in terms of the way that this is drafted? Because if you look at the plain meaning, it seems pretty straightforward. So help me to understand how that wouldn't be correct.
Well, I disagree with the premise that that the plain meaning is clear. So the answer to your question is no. I don't think so. I think it's properly an issue before this Court.
But the words are pretty clear, and the language, even though it gets to the result that might be kind of, interesting, the words themselves are pretty clear. The result might be unintended, but the actual language seems to be specific. So I apologize for nothing, but help me to kind of navigate through that.
Well, let's take, for example, the word member, because I think that probably is at the heart of this conversation here. Assume for the moment that the State Bar of Michigan falls within the other body exception to the Whistleblower Protection Act. You guys know that we don't agree with that premise, but assume that's true, okay? Then this Court has to interpret what that term member means within the context of the Whistleblower Protection Act. The word member can mean lots of different things, and in fact, if you look at the State Bar itself, the word member has at least 3 different meanings. It can mean a member as in somebody who pays dues and holds a card. It can mean member of the Representative Assembly, and it can mean member of the Board of Governors. Those are 3 different types of members just in the State Bar.
Well, interestingly, the statute says any member of that body.
Correct.
So I mean, if it's any member, does it matter if there's 3 distinguishing types of member?
I still think it gets to the heart of the member has to have some meaningful authority within that body. Yes, any member who has the ability to...
Where do you get that from in the statute?
that's the intent of the
It's just
legislature and the
what-
statute itself. In other words, if the intent of the legislature was to give any person, let's take the absurd example of a janitor who works for a public school. Okay? If the intent of the legislature was to make that person a public body, they wouldn't have gone to the pains of defining what a public body it is at all. They would have just said, you can make a report to your cousin or your aunt or your mom or anyone on the street, it doesn't matter.
So I'm interested, your brief talks about the definition of report, and you suggest that the plaintiff here didn't make a report because, kind of for the same theory you just spun, which is she didn't make a report because she didn't tell somebody with the ability to do something about it. And that report means something like to formally accuse. So that seems plausible to me, but I'm wondering, did you press that argument in the Court of Appeals?
In the Court of Appeals,
or in the trial court?
No. Really, the argument that was being made in both lower courts was that because an attorney is an officer of the court, it fell within that sixth exception. So that was plaintiff's primary argument made below.
I see.
So this was not argued, that issue was not argued in detail in front of the Court of Appeals, no.
Okay. Does that mean that you've abandoned the argument here? Can you
No,
still
I think we've
make
raised the
claim
argument
here?
in our,
Well, I know, but
I
if
think
you
we've made that argument in our
If you
brief.
didn't present it to the lower courts, can we determine it on your report theory? I'm just looking for help with the preservation.
well, frankly, I think that's a question for plaintiff. In other words, if plaintiff's argument below was only that an attorney is a public body because he is an officer of the court and therefore a member of the judiciary, was it proper for the Court of Appeals, right, to go beyond that? I don't think so, because the Court of Appeals reviewed it de novo.
Got it.
And appeals courts, when they conduct statutory interpretation, that review is de novo.
Got it. And so we could do the same?
Yes,
Okay.
correct.
Counsel, clearly the State Bar is an organization that's sui generis in some respects. I mean, just kind of looking at it, generally I'd say it's kind of unusual in the sense of being a public agency that has as its compulsory membership, members of the bar and members of the bench. That is a compulsory membership. Involved in that are compulsory dues that we have to pay to that organization. There are compulsory regulations to which members of the bench and bar are subject as a result of that membership. And in summation, it seems to me the only public body that I can think of that actually has dues-paying members. All those kind of go to characterizing, at least in my mind, the bar as an organization with some sui generis characteristics. But having looked at all those sui generis characteristics, is there anything among those that really undermines the relationship between members of the bench and bar and the Michigan State Bar in terms of us being members of that organization? All these things are kind of odd, they're kind of distinctive, but do any of them detract from the essential relationship between the relationship being properly described as one as being a membership relationship? If so, how?
I am not sure I understand what the question you're, and I apologize for that. Is your question going to the heart of the
Despite all these
relationship?
unusual characteristics that characterize the State
Sure,
Bar,
right.
how do any of them go to undermining the basic relationship between the lawyers and the judges who are members of that organization as
Right.
being members of the organization?
Oh, I see what you're saying, right. Well, I don't disagree that there are different definitions of the word member, and the word member has different meanings in different contexts, right? So, yes, attorneys, in one sense, are members of the state bar.
Okay, so
Yeah.
don't you lose?
No, because there are.
Is it the report that's the reporting language that's the problem? Is it the public body language that's the problem?
No, I disagree. The word, the way the Whistleblower Protection Act uses the word members doesn't contemplate that it uses that word in the broadest sense the way that any organization uses the word members.
We'll make that argument.
Okay? The way the Whistleblower Protection Act is using that word members has to mean by virtue of membership such that you've got some sort of authority to do something about a legal wrong.
What about what?
And where in the statute is that?
So-
Yeah, why, where is that in the statute?
Well, it goes back to the,
It might make, like, maybe it would be a better statute if it said that. You must report to a member of a public body with the ability to do something about it. But it doesn't say that, so we have to get it from the words. that
right.
we've
I
got.
think if you don't apply that meaning, though, then you're not ascertaining the intent of the legislature with respect to the statute, and you're
But
not
we start with
reading
the
the meaning of the
words.
word in the context of the statute.
Okay, right.
I think
so-
you're reading it in a vacuum.
So we never want to let purpose trump text, although purpose might inform text, but we never want it to trump text, and it sounds to me like you're wanting it to trump text, and that...
I don't agree. I think the term member can have different meanings, and in
So-
our brief, we've cited, for example, Black's Legal Dictionary that has a definition of the word member that would be appropriate to apply.
But
So
Counsel,
let-
I'm sorry.
Well,
Joan, I
Can I
apologize.
direct you towards an argument that I find a little more attractive, which is
Sure.
report? So there are lots of definitions. You cite one in your brief. Various dictionaries. The Oxford Reference Dictionary says a report, to report, one definition of report is to make a formal accusation about an offense or offender. Webster's 11th says to make known to the proper authorities, as in to report a fire, to make a charge of misconduct against. Another says to make a charge about something, so, et cetera. We could keep going. If report carries that meaning, does that do the narrowing work that you want to do?
Yeah,
So
I
in other
mean,
words,
really-
it's not a report unless you are making a formal complaint, and you can't make a formal complaint with somebody who has no ability to act on the complaint. Otherwise, you're just gossiping. I mean,
Correct, yeah.
you're telling about, but you're not making a formal complaint.
And I agree with you. It gets to the same concern about the Court of Appeals ruling whether you do the analysis under the word member or under the word report. You're exactly right. In other words, if I make if I tell my little sister something or my best friend something, we wouldn't call that a report. We would just say, you told them that, right?
It's a report in one sense. Like a news
It's a
reporter
report.
reports
Yeah,
on,
It's just not a report maybe in the sense that this statute is
Yeah.
supposed to cover, right?
Yes.
I mean, it's a report, like, in the broadest sense of the
Yes.
understanding of that term. But does it make sense in the context of this statute to define it that broadly? So that if we're gossiping and I, mention that this went wrong, that should be covered?
That's correct, and that's exactly the argument we're making. I would point out, too, that in addition, when you think about the relationship between an individual and his or her attorney, okay, an attorney is really just that person's agent. They don't have any independent authority to act except with permission of their client. So when you make a report to your attorney, you're really just reporting it to yourself. You really haven't done anything. You haven't taken any affirmative action.
Wait. If I make a report to my attorney, isn't my attorney an officer of the court? So doesn't an attorney have a large... I want to go back to the issue of member, because when you look at the word member, you had argued that ultimately, this person had to have a leadership role or had to have a certain authority to do something. But don't you think when the legislature crafted this, when you say member, especially as you apply it to the Bar Association as a public entity, isn't the nature of an attorney, it's a different situation. Doesn't an attorney have, any attorney has a greater authority or a greater ability to act on it? So when you say member of the Bar Association, it doesn't have to be the president of the Bar Association, does it? It can be any member of the Bar Association, because lawyers by their nature have the ability to act on a report, which is their requirement in many situations as officers of the court.
Yeah, but I think we have to take that back into the context of the definition of public body we're talking about. And what we're talking about is an individual who we're saying is a public body because they are a member of the State Bar of Michigan. I, because I hold a dues card, have no authority to do anything within the State Bar of Michigan. The Board of Governors does. For example, the Board of Governors can investigate courts, but I do not. I have absolutely no rights or authority within the State Bar.
But you don't have a higher realm because of the nature of the organization. You are a lawyer. And as a lawyer, you have the ability to, I like this word, sua sponte, take action in terms of situations that affect people.
Well, I hope that's not true, because I thought my lawyer could
I was
do what I
gonna
told
say.
him.
No, I
Right.
understand, but
Right.
I don't think I
want a different lawyer than
no,
his
no, 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 no. But I hear exactly what. No, I get what she's saying. I totally get it. You understand the bigger meaning of what I'm saying is that the lawyer is basically the essence of being a member. A lawyer is the reason that the legislature kind of emphasized the word member as it pertains to the State Bar Association is because a lawyer is an officer of the court. And does that not connote a certain level of authority within the organization that they serve within?
No.
That's kind of what I'm trying to get to.
No,
I get we got sidetracked, but that was the
well,
emphasis that I want to make.
First of all, I don't agree that the legislature ever contemplated that the State Bar of Michigan might fall within one of the definitions of a public body when they enacted the Whistleblower
But what would it
Protection
be?
Act.
What would it be then? If it's not a public body, what is the State Bar Association?
The State Bar Association just is it's a public association that falls within the judicial branch of our government. That doesn't make it a public body.
I'm struggling with everything that we're talking about. I really don't know where it all fits into what seems to be a very broadly drafted statute. And you may well be right that the legislature never meant for it to be drafted as broadly as it is here, but we're just trying to figure out what to do with. But there's something to me that I don't know if appeals is the right word, but I'm with you on the my lawyer is my agent. So it's like telling myself something, and frankly, that person is not entitled to do anything with it unless I tell them to do something with it. In fact, I think they would be. I think I could sue them if they did something with it when
Correct.
I didn't want them to do something with it. I think that's how that works. I think that would be malpractice. But on the other hand, the statute, so I could imagine a situation where, the Chief Justice is embezzling and I come across it. I have someone new to tease, sorry. Bob's not
We're
here
stretching
anymore.
our imaginations here, but okay.
Yeah.
That's a hypothetical.
Yeah.
Krista,
This is an obsession.
But I'm like, oh, wow, Chief Justice Markman is an embezzler. Like, this is bad. What am I going to do? And it's so, dicey. And I think, well, I better call a lawyer first. So I call my lawyer to figure out how to do it. And then my lawyer says, I think you probably should report it, because if you don't, you are, you might be, in trouble. So let's go to the Attorney General. And I say, you do it for me. I would like you to handle it. So my lawyer goes to the Attorney General. I think under the statute then, if the Chief Justice fires me, I don't think you can fire me, but if you did, I think I'm good, because the statute says either, the employee or an agent of the employee. And I think under those facts.
Correct.
But was that alleged here? Is that on the table in this case? That when the plaintiff called her lawyer, she was calling her lawyer as an agent to sort out what to do, and even if I know there's a dispute about then, like, causation, like what happens about how the, person actually gets served with the PPO, and I'm not sure any of that matters for our purposes. Is there a theory that, her lawyer was acting as an agent, so she's still somehow covered? Alternatively, is there a theory that her call to her lawyer is some evidence of her, reporting a suspected violation of law? Is it, or are those theories that haven't been argued by the plaintiff at all, and I have to stop and get out of my rabbit hole?
Okay.
You can tell me that.
That's okay. Sure. I mean, the facts are that she called her lawyer because she was returning a phone call from her lawyer, first of all. Okay? And she was returning a phone call from her lawyer, and what her lawyer said is, by the way, I haven't been able to serve the PPO yet. What do you want me to do about it? And she said, she's at my workplace. She's here at the medical center. She's very ill. She might die. Let's hold off until we know more, until we know whether she's going to live or not. Okay? So she was talking to her lawyer as her agent in trying to sort through what to do about the service of this PPO.
Mm-hmm.
But isn't there a larger, going back to the conversation, the dialogue that we had before, isn't there still a larger scope that's at play here, which is she was, in this situation, in this circumstance, she was making a report in the concept to a member who is also an officer of the court.
I don't know that it matters that an attorney is an officer of the court. I don't think by being an officer of the court that makes any attorney a public body under any of the definitions of the Whistleblower Protection Act.
I'd like to ask you one more time about member.
Okay.
As best as I could discern, the only distinction you drew between what I think opposing counsel's understanding of member is and your understanding is that your understanding requires some more direct ability to exercise power within the institution.
Correct. For example, a member of the judiciary, a member of the legislature.
Well, that's one definition of membership. The definition you seem to be somewhat dismissive of, though, is the one that we, the people, have, which is basically to select representatives to represent us in Congress and the state legislature and other institutions. Members of the bar do have that indicia of membership, don't they? We select members of the state bar governance board, right?
Yes, correct.
Okay.
Yes.
Why is that not given more regard in your analysis of what membership is all about?
Is your question because an attorney has a vote as to who's on the Board of Governors, does that give them some sort of authority, enough authority within the state bar?
Well, I think we feel that American citizens have that authority
Sure.
in terms of governing their nation when they have exactly that same relationship between the governors and themselves.
I don't think so. I think if you look at the intent of the legislature here, the member has to have some ability to redress a legal wrong, to address the violation.
What if
Simply
you're not
having
on the
voting rights, I don't think
What
is
if you're
enough.
not on the Board of Governors, but you're on some other committee? You're not the president of the bar, you're not on the board, you're not on the representative assembly, but you serve on a committee. Does that now heighten your status?
Depends on what committee it is. Can you
Does
give
it
me more
have
facts?
Yeah, I
Does
was
it
going
have
to
to be
say,
a
I think it
specific? No,
depends on.
I was just making the argument. I mean, I guess the question is that that's why we have to go with the context, or not the context, but the actual language, right? Because, most lawyers are part of different committees and serve in different capacities. Is it your argument that the legislature, when it used the word any member, has to be the president? Or the representative assembly has like 50 people on it. So does that constitute as I guess where we get vague and why we have to go to the statute is, isn't the argument a little ambiguous as to kind of who has authority within the Bar Association to kind of constitute the definition that you're using?
I don't think so. I think only the Board of Governors has authority to redress some sort of legal violation.
So if somebody reported some misconduct to a member of the Board of Governors of the State Bar, that would in fact
Yes.
trigger the Workers'
Yes.
Whistleblower Protection Act?
Yes.
Okay. Okay. Any further questions? Okay, thank you. Counsel?
I was going to say good morning, Your Honors, but it's actually good afternoon, Your Honors. Russell Babcock, I'm here on behalf of the appellee, Tammy McNeill Marks. And I realize Your Honors have had a chance to review the briefs. And I guess part of the dilemma that's coming forward today is the arguments of defendants have kind of evolved and changed through the process. At the appellate court level, at the Court of Appeals level, their argument was that this wasn't a public body, and therefore my client's attorney at the time obviously wasn't a member of such a public body. Now that seems to have evolved, and now we're talking about reports. And in fact, they want this court, have asked this court to adopt additional requirements that litigants must now have to prove, and that is that they must go to an independent third party. This is coming from their supplemental brief on page 5. Now they're talking we have to go to an independent, whatever that might mean, third party. And that third party must be able to take action. And as Your Honors have pointed out throughout the discussion today, where is these types of language? You guys are looking at the statutes, the same statutes that we've all been looking at. Where are these additional obligations being set forth within the statutes themselves? And I think Justice Bernstein, I know other justices brought it up as well. Isn't this a question for the legislature? These are wonderful suggestions, maybe, to have the legislature revise the law, but the law is what it is. It's black and white. There are no ambiguities. The ambiguities are being created because of their arguments about the intent, which they've turned to the legislative history. Now they're turning to definitions. But the fact of the matter is a member is a member. The State Bar is a public body. And my client did contact her, did speak to her attorney. She did tell him that this lady had showed up at her workplace. This is an attorney that was representing her in a pending PPO matter. He is an officer of the court, as Justice Bernstein pointed out. I'm sure no one disputes that. But this was not, as defendants like to characterize it.
Let me just tell you, I've studied this statute. I find it difficult to get through, but at times clear and at times not so clear. The statute defines, I'm struggling with report, and does report mean recount, which might have happened here, or does report actually mean disclosing for purposes of correcting, which may not have happened here? In any event, let's go beyond that and to the actual statutory definition of public body. There are 6 subsections that define what a public body is. There seems to be a catch-all, any other body, right? There's a catch-all, and that's where you say you believe the State Bar falls into this, or at least that's where the Court of Appeals found it, right? Interestingly, though, that catch-all is item 4 of 6. Usually in statutory drafting, we see the catch-all at the bottom. It describes a series of things, and then any other typically would mean anything other similar to the other things. All right, the related words canon of construction. So here what we have in the 4th slot, which I find strange, and I can't account for it, any other body which is created by state or local authority or which is primarily funded by or through. All right, what meaning do I give to the word other? What any other body? Do I not have to look at the 3 above and say, okay, something similar to that?
I take it as the state legislature recognizing this, and this is how I take it from reading on his face, that there's a very broad definition of public body, that there are lots of different entities that function in this state. And in the federal government, we've extended it to federal agencies as well, as Your Honors are aware, in some of the recent decisions. So I think and I don't think what's a catch-all is it's acknowledgement that we're not going to limit it to a particular type of entity. We're going to go and we're going to take a very broad approach.
Well, if it means everything, though, then don't the other 5 sections become superfluous?
I don't know about that, Your Honor. I think that there comes a point in time there may be some that they were more readily ascertainable, but then I think the state legislature acknowledged that there are other ones that in other words, instead of listing 6 items, they could be listing 50 items. And I think they're just trying to make sure that they make their intent clear. At least that's how I read the language, of making sure it's very inclusive, it's very broad, it covers any type of governmental entity, essentially. Whether or not that was a wise decision by the state legislature or not, that is a question for the legislature. But
we have statutory rules of constructions, canons of constructions that help guide us when we have these questions. And one says that you don't read a statute to render superfluous any other portion of a statute. So it can't mean everything, otherwise there'd be no need for the other 5 pieces.
Well, I would agree. I mean, the word other does, it basically encompasses the other items above and beyond the first
So
four.
if it's in line with the other, the first one seems to be everything relating to the executive branch, any body, anything that grows out of the executive branch, including employees. And you think about the executive branch, we're talking almost all exclusively governmental employees who are doing different governmental functions. And it's very broad, a state officer, employee, agency, department, division, but all of the executive branch. Likewise, the second is for legislative branch, but again, talking about governmental employees doing certain governmental functions. The third then goes to municipal or local, county, township, villages, and the like, and things that arise out of there. And then the fourth, we get to any other body. And I see the state bar, we don't have public employees running the state bar, and there doesn't seem to be a defined governmental function for the state bar. So why would the state bar be other as similar to the others listed above?
Because when you read that provision, and I have quoted it, here it is. It says, and this is where it gets into it, any other body which is created by state or local authority, that's the first qualifier. In this case, we have a statute, federal statute, state statute, and a series of statutes that pertain to the state bar and created it and establishes it. And that's the first. So we satisfy the first provision there.
Okay.
Or which is primarily funded by or through state or local authority or any member or employee of. So what I'm saying here, Your Honor, is
we don't get to the or any member or employee until we determine that the state bar is a body.
It
right?
is a body.
We got to get there before we get to that last clause.
Sure.
Do you take it that the second clause that is primarily, is the state bar primarily funded through state and local authority? Do you take that position?
I don't, the position, I have not researched that, Your Honor. I'm assuming it's public knowledge as to how the state bar is funded. I know that the state bar is regulated.
Oh,
and
I know they take dues
we
for
pay
me,
dues every
right?
year.
And if I could go to my township and tell them to pay my dues, that'd be great, but I don't think I can. It seems to be funded by the individual members.
That'd be myself. I don't know if they get any secondary funding beyond our membership.
So is any other body which is created by state or local authority? And you're essentially saying, well, we have a statute that creates it, but we also have a statute that defines how to create a corporation in Michigan, right? There's the ABC Company Incorporated, a Michigan corporation. Is that not a body that's been authorized by state law?
Well, I don't think that's, I mean, again.
Exactly.
Yeah.
You'll give me that.
So, yeah.
That's too broad, right?
I'm not, it's the legislature's role to decide how broad they want to
Well,
make it.
either you're telling me that it does cover every corporation, or you're telling me it doesn't.
It says any other body which is created by state or local
So
authority.
does that mean every corporation in the state of Michigan? That's a Michigan corporation?
I have not seen that. No one's raised that argument prior to today, Your Honor. I have not I haven't read that statute, so I'm not aware of what it states.
But aren't we here to give meaning to this statute? That's what this is all about.
Well, the issue is not whether or not, that may be a question for another day, as to whether or not it applies to a company, a private company. And I'm obviously, no one's briefed that issue. No one has even raised that as a question. The issue that was before the court was whether or not the State Bar of Michigan is, and under the definition that the state legislature provided, it certainly falls within it. Now, whether or not it can be taken to another level down the road, that may have to be dealt with another time. And we obviously don't have a private entity at this point. The case law is very clear that this is a public
It's quasi-public. It's a quasi-public body. It has some public purpose, but it's actually run by private individuals, because the employees of the State Bar are not public employees, and the members pay the dues, and it's the membership that runs the body, right? The membership elects the Board of Commissioners.
But they are regulated by both statute. There's other statutory provisions that are around that same section that talk about obligations of the State Bar. There's also obligations that have been answering to the Supreme Court.
Yeah, but lots and lots, many private companies are also regulated by state statutes, so that can't be the answer.
Well, I mean, what I'm just saying is that it's not authority to create an entity. This is authority. The statute actually created the entity.
Right,
The State Bar was created by statute. It's not, Bob's LLC was not created by a statute. In other words, there was no statute that says Bob LLC shall not exist.
Right, fair enough.
That's a distinction that exists between a private entity.
You've got a lot of language that supports your position that the other side didn't seem to want to acknowledge. They wanted to go more to purpose. But now you're saying, well, this is actually created by statute, but it doesn't say created by statute. It says any other body which is created by state or local authority. And that's, there's authority out there to create a corporation, and it's state authority, and they call it a Michigan corporation.
And the answer,
I think that's just to me, that's too broad of what the legislature could have possibly meant. And if that's the case, then what is it? What is the other body? What is it in other that we're looking to? Is it the items, the 3 listed above? Is it the 2 listed below it, law enforcement and the judiciary?
I've always looked at it as being an effort by the state legislature to be all-inclusive, and whether or not it was, and that was how I've always interpreted it.
So let's go with your all-inclusive. And I want to give you a hypothetical, which sounds like a joke. 2 lawyers walk into a bar.
Yeah.
Okay.
The Illinois bar or the Ohio bar?
A Michigan bar. 2 lawyers walk into a bar defined as a drinking establishment, not a bar,
Licensing.
not a licensing organization. So they walk into 2 lawyers walk into a tavern.
Okay.
The one is a criminal defense attorney whose client has come to him in the course of an attorney-client relationship and has disclosed other crimes that the defendant committed, and the attorney to whom this has been disclosed says to his buddy, his drinking buddy, also an attorney and member of the state bar, "Hey, you'll never guess what my client told me today." And then he discloses all his client's confidences, which is illegal. I mean,
Assuming he didn't have permission to do so.
assuming you did not have permission to do so. His boss turns out to be sitting in the booth right behind and says, "Wow, Attorney A, my employee, really doesn't understand his ethical obligations to his client," and fires him because of the communication that one member of a state bar made to another member of the state bar. He says, "You can't fire me, whistleblower." Does he win?
I would argue that, and that's hypothetical, he should win. But and again, it's because of how.
So isn't that a little head scratching? Like, doesn't that make you think, huh?
Well, Your Honors, as Your Honors are well aware, again, I think these are all good questions for the state legislature. And again, we're seeking to look for the intent beyond what the state has deemed appropriate.
So then let me ask you this question. If there is a plausible definition, like if I can look in a dictionary and find many dictionaries that have a meaning of report, because you must make a report to a public body, even if we concede member of a public body. But report means to make a charge against as to a superior, to make a formal accusation about, to make known to the proper authorities. Why wouldn't we give it that definition, which would preclude my crazy hypothetical?
Well, first off, Your Honor, certainly the state legislature could put a definition. They obviously chose not to limit the scope of the word in any fashion. I think
Is
certainly.
that right? So is your position whenever the legislature doesn't define a term, they must mean the term to be read in its broadest possible sense?
Well, I would think so. But but let me answer your question more specifically with regards to the facts of this case. She did make known to an appropriate person, i.e. an attorney who was representing her in a pending PPO proceeding that was pending at that point in time. And the context of it was obviously with regards to the PPO matter. The fact that there was a violation by her showing up at her workplace. She shared that with her attorney.
But is it true? Do you agree with the facts that opposing counsel articulated that she also told her attorney not to do anything about it? Is that
There was some discussions with regards to how they should proceed. There was some additional information that became to light, and ultimately.
But if that's true, if she said, "Let's not do anything about it, she's about to die," then isn't she clearly not reporting in the definition, in the narrower definition that she wants something to be done about the information?
Well, Justice also pointed out to make known, and that was something she made known. She made known that there was a violation.
I grant you if it's the broader definition. If it's just report, I said this to somebody else, then that's that. But if it has to mean something more than that to make sense in the statute, and it has to mean giving the information for the purpose of having something done about it, maybe you still win because maybe she wants to do something about it and then thinks differently, and the lawyer kind of gets her to think differently about it because either the person's about to die or there's might be a HIPAA problem or some other problem.
Well, that's
but given those facts that she gives the information to her lawyer and then says don't do anything about it.
Well, the fact of the matter was that that was part of the discussion. As we all know, that's the role that a lawyer fulfills. That's why the state legislature enacted the Bar Association, so there could be legal representation of licensed members, and that's why when you go to an attorney, they can serve as your legal advocate. They can also serve as your advisor, and that way, and that's part of the purpose of this is to make sense of what has happened. In other words, she felt there was a violation of the PPO. Her counsel, her attorney, who was a member of the State Bar, advised her to the options. Okay, are we or are we not going to bring that to the court's attention? But the moment they entered his head, being told to him, that's when it entered into...
Ironically, I think if the attorney had brought it to the court's attention, she'd be clearly covered under the statute, because then the attorney would have been her agent and brought it to the attention of a public body who could do something about it. So it's almost like because the attorney talked her off the ledge, you know, if we think reports should be defined more narrowly, she's out of luck.
But
I don't know how that cuts. I'm back in my rabbit hole. I would like to get out.
But as the Brown opinion points out, you start getting into this. Do you need to take it to a higher level? Do you need to take it to an authority? The Brown opinion made it clear you don't have to. You can go to a lateral. You can go to a coworker who's sitting next to you if you're a government employee, you're sitting next to the coworker at a water cooler and bring it up, and you get fired for it. I mean, under Brown, you know, you don't have to go to a higher authority. You don't have to take it outside of your
You have to report, though.
But you have to be by reporting, by making it known to the other party what you are aware of. And that's what she did here. So,
But on your theory, there's no requirement that the attorney be her attorney. It happens that the attorney was her attorney, but there's no requirement of that. I can just go out to any of these people, like the law clerks sitting here in the back, they're attorneys, so I could just tell them something and then be immunized because they happen to hold a bar license. They don't have to be my attorney, even though they're all excellent. I would hire them.
In fact,
Good example.
Counsel, please, you don't even need to go to attorneys. You can go to law students because they also can be members of the State Bar.
Yes, but Your Honor, you're absolutely right. And you have a witness. Let's say there's a witness to a violation of the PPO, and she goes to my client's attorney and says, "Hey, there's a violation," and she says, "Great, I'll take it to court. I mean, this is great news. I can use it to help advocate this violation of the law." The witness gets fired. That would be an example of a protected activity as well. So whether it was my client or someone else coming up to my client's attorney, sharing this information, if they thought it was a violation of the law, they both would be protected. So, I mean, at the end of the day, I know how many times up, Your Honor, at the end of the day, Your Honors, I think Justice Bernstein has said it best. A lot of these questions are questions that should have been raised first. Before I get there, should have been raised first at the Court of Appeals level. It wasn't. This issue what reporting was never raised there.
Your time is up.
Thank you.
Case is submitted. We'll be in recess till tomorrow morning. Thank you.